Let's move to Constitution now. You often talk about the importance of Constitution. There is a basic structure of the Constitution, and if I am not wrong, you also mentioned about it. Now, from when do we start this basic structure of the Constitution? From the time it was adopted? From the time it was adopted? Or from the time these two words were added to the preamble, secularism and socialism? Because if we go by the fact, if you say that it should be, the basic structure should be from the time it was adopted, then this insertion of these words, even if by the parliament, is a violation of that basic structure, logically. I'm not debating about the two words, but so how do you see the basic structure of the Constitution? Because one former Supreme Court judge has also said that we need to debate actually the basic structure of the Constitution.
Kaushik, the answer to your question is very simple. When a court, especially the Supreme Court, declares the law, the declaration of the law, insofar as the Constitution is concerned, goes back to the inception. Unless the Supreme Court says that the declaration of the law will be prospective. So the Supreme Court can today say that, well, we are ruling this to be the legal position, but it will take effect from 1st of October 2025, in which case it will have prospective effect. Otherwise, the general principle of law is that any declaration of law is always retrospective. And insofar as the high courts are concerned, they have no power of prospective overruling. So to answer your specific question, once in 1973, 1st of April 1973, if I'm not wrong about the date, the Supreme Court in Keshwanand Bharati's case said that there is something called the basic structure of the Constitution. What is the basic structure? Democracy, equality, liberty, fraternity. Once that was said, that is a defining feature of the Constitution as it was originally adopted. The concept of basic structure, in other words, will not be with effect from a much later date. But to my mind, it defines the original features of the Constitution. Otherwise, look at how absurd it would be. Can we say that because democracy was inserted in the Constitution before 73, democracy is not a part of the basic structure? Obviously it is. Equality. Article 14 was always a part of the Constitution. Can we say that that's not a part of the basic structure? Obviously, it is a part of the basic structure. So the question really answers itself.
Of course. So you mean to say, Justice Chandrachud, because these two words were inserted much later, even after 1973, so these two are not actually part of the basic structure? Secularism and socialism?
So you see, there again, as in the law, you must always understand the nuance. Is the insertion of a word in the Constitution, does the insertion bring about a change in the legal position for the first time? Or is the insertion a recognition of the position as it already existed in the Constitution? Now, one way of looking at it is this, that the Constitution, when it was originally adopted, by the Constituent Assembly, and then brought into force in 1950, the Constitution always spoke about the equality of faiths. The Constitution always spoke about your freedom of conscience. So one way of approaching it, in fact, I have said it in one of my judgments, that is to say that the Constitution as it was originally enacted postulated this fundamental pluralism of our society, the need for inclusion, a recognition that we are a multicultural, multi-religious, diverse society. And there are various provisions of the Constitution which give vent to this particular doctrinal position. Once you accept that, then a particular insertion may be only a recognition of a position as it obtained. Now, secularism, as you know, came in as a result of the 42nd Amendment, which was the emergency amendment. There are two views. One way of looking at it is, well, it was brought in 1976. The contrarian view is, but it's just a recognition of what the Constitution always assumed as a fundamental principle.
Okay, I just want to bring a photograph. We have just 4 minutes. I want to bring a photograph because I want to look at your personal compass. One thing is the judiciary's compass. Take a look at this photograph because it caused controversy. Looking at that photograph, critics of you, because you mentioned social media, immediately said, Justice Chandrachud has set a dangerous precedent blurring the lines between the judiciary and the executive. How do you respond? Narendra Modi ji coming for a puja at your house, all of it photographed. Do you believe it set a dangerous precedent blurring the lines between the judiciary and the executive?
Rajdeep, there were two criticisms of people who criticized. The first category of people had a problem that I openly accepted the fact that I perform a puja. I make no bones of the fact that I'm a devout Hindu, that I'm committed to my faith. But interestingly, let's not forget that the oath which a judge of the Supreme Court takes, the oath begins by saying, I do swear in the name of God that I shall bear true faith and allegiance to the Constitution of India as by law established, or you, of course, solemnly affirm. So our Constitution is not agnostic to religion, nor is our Constitution opposed to religion. That's the first.
Yeah. The second.
The second that I want to postulate is this. Though each of us as judges are entitled to believe, pursue our own faith, whether we are Hindus, Buddhists, Jains, whether we are Sikhs, whether Zoroastrians, the justice which we do is even-handed among communities. Every single day, if you look at the cause list of any court, you will have communities across the board seeking justice, to whom even-handed justice is delivered. Third, and the third point which is about the Prime Minister coming to the residence of the Chief Justice. If people have an objection about the Prime Minister, well, this was an easy handle to target the Chief Justice for inviting the Prime Minister. Between constitutional functionaries, let's have an element of how we are not leaders of opposition parties. The judiciary and the executive, the Chief Justice of India is not the leader of the opposition. Of course, in the work which we do, we are independent of the executive. The Prime Minister visits the homes of judges when there is a marriage in the family. When my mother passed away in 2014, January, when I was in Allahabad, the Chief Minister of Uttar Pradesh then came to my house to visit me with his wife, just the four of us. So these are elementary courtesies of constitutional office. They have nothing to do. And the ultimate test, Rajdeep, is this. How is that person performing as a judge?